Story 1. Opposing counsel. Isn't it true you hit the victim in the face with a brick? Client. No. Marcus hit him with the brick. I hit him in the back with a piece of wood. Story 2. He had sent a photo of his wife's beaten face to her with the message, "Do you want this to happen again?" He had come across well in court until that point, but his mask slipped when the photo was revealed. Story 3. A friend of mine who worked as a public defender had a case in which a woman was arrested on drug charges. She insisted she had no drugs on her at the time, and he thought that would help. It turned out she had no drugs on her because she had just sold them to an undercover police officer. Story 4. My house was robbed. In addition to the other items the thief took, he stole many of my suits and all of my neckties. I had a large collection of about 100. He left fingerprints on a hard plastic box where I kept spare change. 3 months later, the same detectives were handling a burglary in the neighborhood, and the suspect's fingerprints matched the ones from my house. At the thief's arraignment, I saw him wearing my suit and tie. I told the district attorney, who said there was no way to prove it. However, the tie he wore was a one-of-a-kind street map of San Francisco, and I still had the documentation to prove it. The district attorney informed the judge, who ordered the thief arrested again for possession of stolen property. The thief's lawyer was dumbfounded. It was a satisfying end to a difficult situation. Story 5. Custody case. The client failed to tell me he had previously been convicted of felony child abuse for breaking 16 bones in an infant's body. Story 6. A little late to the party, and as a disclaimer, not my client. The company I worked for at the time was conducting due diligence before acquiring a small technology startup. The chief operating officer of the startup was well-liked, friendly, and outgoing. We had heard rumblings that he was overly hands-on with the work and with female employees. Apparently, there was a proposed severance arrangement that would allow him to keep a sizable portion of his post-acquisition bonus because a young woman in their sales department had filed complaints with human resources and obtained counsel. I sat in on a meeting with the chief operating officer and the company's retained lawyers while they questioned him about his contacts with the woman. He denied ever having contact with her at work without multiple other people present. Those other attendees said his behavior toward her during meetings did not raise concerns. He emphatically denied having any contact with her outside of work. The lawyers asked the question multiple times in different ways, and each time he denied any out-of-work contact. Later, we met with the woman and her lawyer with the chief operating officer absent. Her lawyer presented a rather explicit card that had accompanied a bouquet of flowers addressed to her from the chief operating officer. The man had an account with a florist linked to his credit card. When the company's retained lawyers confronted him, he said, "But I never had contact with her. It is not like I delivered the flowers myself." The chief operating officer was terminated for cause and did not receive a severance package. At her request, the woman was given paid time off until after the acquisition and was then transferred to another company within our group. Story 7. Lawyer in the United Kingdom. I acted for a member of a well-known pedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that was not available to him in statute or at common law, contrary to my advice. I followed his instructions as I was bound to do. He said, "If the state will not punish pedophiles properly, then it is left to men like my client to take the law into their own hands." That is a false argument for many reasons. His laptop was seized by the police and submitted for forensic examination. It contained a staggeringly large database of child pornography. He himself was a pedophile. Story 8. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and often the client is not there. If you get blindsided by something critical, there is often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55 zone. No big deal. If she did a driver improvement course, the court would usually dismiss or reduce it, since her driving record was not bad. When I showed up for her, I found out she had been driving 70 miles per hour up an unplowed snow lane to get around the other cars traveling in the plowed lane because they were driving too slow. I did not know it was even possible to drive 70 miles per hour on fresh snow. The officer said he had already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he did not feel comfortable reducing it under those circumstances. When I called her after court to confirm, she said she had simply forgotten to mention it. That detail alone meant hiring a lawyer was a waste of money and the hassle of taking an 8-hour class. I give honest assessments during consultations about whether a case is worth pursuing, and by omitting that detail she harmed herself for no reason. At least she took it well and did not get defensive. Story 9. A friend of mine is a defense attorney. He was representing a man with a lengthy record for assault. The man took an air conditioning unit and threw it at his girlfriend. My friend says he was able to get a plea deal for 1 year of probation and no jail time. The judge was ready to accept the deal when he asked the defendant if he had anything he would like to say. The defendant responded, "Yeah, I don't know why they're charging me with assault. I never touched her. I just threw an air conditioning unit at her. This is bullshit." The judge rescinded the plea deal because of the defendant's attitude and lack of remorse. The case went to trial and he was sentenced to a year in jail. Story 10. The client said his ex owed him a lot of money and was trying to avoid repaying him by obtaining a protective order. Seemed reasonable, so I took his case. At the hearing, it emerged that they were never a couple, that he had been sending adult toys to her residence weekly, and that she had not asked for the thousands of dollars he had given her over the years. She worked as a stripper. We lost. He was laughed out of court and learned a valuable lesson. Tell your lawyer the good and the bad before trial. Story 11. There are so many. I have a client in a custody battle whose opposing party claims he has a drinking problem and he denies it 1000%. After the frank conversation I had with him asking him not to hide things and to be honest, we went into court. During cross-examination, the opposing party produced video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys, and then picking up his child from school during every access visit. He not only did not tell me that, he also forgot to mention that his ex's brother owns a private investigation firm. He was careless. Story 12. He had filmed his offenses for his YouTube channel. The police did not even know. A witness mentioned it on the third day of the trial. That afternoon there was a quick change of plea. Story 13. Employment case. At my client's deposition, everything was set up. The first question was to state her name. The client looked at me and asked for a break. We took a break, and she pulled me into the hall to tell me she had lied about her identity. She was a serial fraudster who had changed identities 7 times since the 1990s. She said she thought the other attorneys had somehow figured it out, and that was why they asked the question. Story 14. Case handled as a paralegal. Negligence case. The client argued that a lack of street lighting and a cyclist he could not see were responsible for his striking a utility pole. Upon discovery, the first respondent's report indicated that the driver was found in the driver's seat with his pants down and explicit material playing on his phone. It was not difficult to determine who was negligent at that point. Story 15. A man in prison hired me to request a modification of his sentence because he was doing well, completing many optional programs and had no rule violations. His family came in and paid to get started. I asked whether he had requested a modification before, because the law allows only 2 modification requests for any one sentence, whether granted or denied. He insisted he had never filed before. After several hours reviewing records and preparing documents, a copy of the case record finally arrived. He had personally filed for modification 6 times since he was sentenced, with handwritten pleadings that were all denied. The request he hired me for was therefore barred and could not be considered. Story 16. I am a court-appointed attorney for qualifying individuals in family matters. This is a termination of parental rights case. I have been arguing that the parent is stable, working lawfully, has a suitable apartment, no longer needs psychotropic medication, and is ready to be a parent. After a few months of negotiating with all parties and the Department of Children and Court Services, we had a pretrial hearing to try to convince the guardians. I met with my client before the hearing to see if anything had changed. She said, "Nope, all good. Let's get my kids." I thought it unlikely, but we proceeded. In court, my client, who was hot-headed and quick to anger, became riled up and began yelling at the guardians in open court. In about 15 seconds, she revealed that she was no longer working, was no longer living in the apartment, did not want a relationship with the guardians despite the children loving them, refused to send the children pictures of the toys they miss, planned to move out of state, believed the family could live on state aid if the children were returned, and was 4 months pregnant. I was too shocked to react. This was not the image of stability and parental fitness I had been trying to present since last July. To clarify, the client had been working hard and had legitimately made significant progress prior to the hearing. I was not making false representations or trying to reinstate someone unfit. This was a true bombshell. I had done my due diligence and confirmed that statutory requirements were met. Things apparently fell apart very quickly. This was an atypical situation. Parents typically do a good job meeting their requirements. Story 17. Not my client, but the son of the opposing party, and possibly the party himself, lied about being blind to appear more sympathetic as a witness. We did not know this until he took the witness stand. When the opposing counsel asked him to take the oath, he picked up the oath card and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole matter in our client's favor shortly afterward. I was a trainee at the time, and my boss, who was in her late 60s, said it was the most ridiculous case she had ever handled. Story 18. I was a law clerk, not a lawyer in this role. This was a typical divorce-related case. The jury trial about splitting assets and who would get what lasted about 5 days. Right before closing arguments, the attorneys asked to speak with the judge because a few days earlier the couple had decided to get back together and had not told the judge or their lawyers. We had heard 4 days of evidence and arguments and brought in experts such as property assessors and financial planners, and the couple was back together. One of the attorneys asked to be relieved from the case and walked out of the courtroom. The judge dismissed the jury. The couple insisted they did not think their reconciliation was something their attorneys needed to know. In some states, divorces have jury trials. In this case, the trial was not for the divorce itself, but for a cause of action stemming from the divorce, namely marital property. Story 19. I am a public defender in an area with a lot of methamphetamine use. Methamphetamine makes most people talk a lot, so I cannot tell you how many clients forget to mention that they arrived at the jail still high and called their mother, girlfriend, or friend on the jail's recorded phone. Not only did they confess to the crime, they also discussed and developed the same alibi or version of events I intended to use in their defense. Note: this is not legal advice. Calls to an attorney are privileged and generally go through dedicated lines that are not recorded, depending on the facility. Calls to family members, friends, and others using the regular phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call explaining this. Story 20. I heard about a man appealing the revocation of his disability benefits. He claimed to be a paraplegic, but the opposition presented more than 10 minutes of video showing him walking, running, and even jumping over a fence. After about 1 minute, the judge said, "Okay, I've seen enough. Please leave." Story 21. A credit card theft and fraud case. When I was a young lawyer in the late 1980s, I tried a man for credit card theft. The witness was a department store clerk. Before video surveillance, the prosecution relied heavily on witness identification. As she described the customer who was buying the store's distinctive clothing, I asked how she could be so sure it was my client. She looked at him. He was wearing an obnoxiously yellow shirt. She said that not only did he completely match her description, but he was wearing the exact same shirt she had sold him. The jury convicted him, and I learned that day to better prepare my clients for trial. Story 22. When questioning trial witnesses, the rule is never to ask a question you do not know the answer to. Despite that rule, lawyers often ask small, apparently inconsequential questions to set the scene. The answers are usually presumed. This case was an exception. The defendant was arrested on a warrant and transported to jail. After booking him, the officer returned to his vehicle and discovered a small bag of drugs in the middle of the back seat. The defendant was charged with possession. At trial, The officer explained that he routinely searches his vehicle before his shift and after transporting anyone in the back seat. The defense attorney tried to poke holes, but the officer's testimony was remarkably consistent. He was fastidious about checking his vehicle, and the appearance of the drugs coincided with the defendant's presence. As the defense attorney ran out of questions, he asked whether anyone else had been in the back seat. It was a long shot. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time. There was no reason to think anyone else could have been in the back seat with the defendant. To their surprise, the answer was yes. The defendant had been with his girlfriend when arrested, and the officer had agreed to drive her to her apartment before taking the defendant to jail. This was not in the police report. The officer did not tell the prosecutor, and the defendant did not tell his attorney. There was a palpable pause as that sank in. Because someone else had been in the back seat, reasonable doubt existed. After proof concluded, the prosecutor offered a half-hearted closing. An acquittal followed. Because of this case, I learned never to assume a fact, no matter how obvious it may seem. Story 23. I am a lawyer, but I was only observing this trial, not participating. The case was that woman A had hit woman B in the head with a heavy pint glass at a bar, and woman B suffered serious injuries. The defense claimed that woman A had not hit anyone with the glass. She had merely thrown it in a random direction, and it accidentally struck woman B in the head, so it was not battery. The prosecution had closed-circuit television footage from the bar, and it was shown at trial. The footage, in high definition, clearly showed woman A walking behind woman B and smashing the pint into her head so hard that it shattered on impact. The defense lawyer's jaw almost hit the table. The prosecutor noticed and said, "Thrown, eh." The defense lawyer replied that, due to technical difficulties, he had been unable to open the closed-circuit television footage on his computer when reviewing the evidence. Woman A was found guilty. I was completely dumbfounded. Story 24. I am not a lawyer. These are my father's stories. He worked as a fraud investigator for an insurance company. I have a few of his stories, here are two. A man was claiming theft of multiple items, mainly a ring. Things were not adding up, so my father and the insurance company's lawyer decided to take a deposition. The man showed up and was giving the deposition when my father noticed he was wearing the exact ring he claimed had been stolen. My father slid a note to the lawyer informing him the man was wearing the ring. Once the note was passed, the man realized what had happened and put his hands under the table to remove the ring. They asked him to stand up, and the ring fell to the ground. Another involved a man claiming a break-in and theft. Immediately things did not add up. The window was broken out rather than in. The man submitted Polaroids of items he claimed were his, such as televisions. In the Polaroids, the reflection of the store where the items were located was visible in the glass. He also claimed hundreds of CDs and records. Oddly, every single title began with R, S, or T. My father was about to deny the claim in person but noticed the man had a gun on the table, so he handled it over the phone. Later, the same man was arrested for murder. Story 25. My father was a judge. I remember him talking about a case in which a woman sued for a severe back injury she said prevented her from working and caring for her children. In the middle of the trial, a pen rolled off the table. She reached for it from her chair, but it was too far, so she stood, bent over, picked it up, and returned to her seat as if nothing was unusual. My father watched her. She snapped at him and asked what he was staring at. He asked if she was okay, and she said she was fine. Her attorney leaned over and said something to her, and she then loudly complained about how much her back hurt, but no one believed her. Story 26. This was the beginning of the end of my marriage. My husband lost his job in the title and mortgage business. He applied for unemployment benefits and was denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing if there was anything he had done that caused them to fire him. He said no, absolutely not. They fired him out of nowhere. On the day of the hearing, he testified under oath that he had done nothing wrong, was a good employee, and had no issues. During cross-examination, the other attorney produced documents from one of his real estate closings that he had forged and backdated. He had to admit he had perjured himself. Needless to say, he did not get unemployment benefits and did not sleep at home that night. Story 27. Now that you put it that way, maybe I did hit the car. Story 28. I was about to complete a land transaction that required my client to have built a road. The entire point of the transfer was the road. My client, before completion, said, "Turns out we did not build the road." Story 29. Not my case, which is a gift from above really. Civil trial before a jury for injuries and property damage from a motor vehicle accident, and punitive damages because the defendant was intoxicated at the time. Before the defendant who was driving under the influence ever stepped foot in court, they would have been prepped repeatedly, first for deposition and then for trial testimony with the standard questions: were there any prior incidents, arrests, or convictions, anything that can be used to impeach the defendant's testimony, for hours. The defendant denied everything and appeared completely blameless. Thus, at trial, defense counsel put the defendant who was driving under the influence on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time they were going through at the time, and otherwise present themselves as an upstanding member of society in order to reduce punitive damages. It went well. Then plaintiff's counsel got to cross-examine. I will paraphrase what happened next. This is hearsay. Plaintiff's counsel: earlier you testified that this was a one-time mistake and you have learned your lesson. Is that correct? The defendant who was driving under the influence: yes. Plaintiff's counsel: isn't it true that you were already convicted of driving under the influence in another state? Defense counsel immediately objected. But the objection was overruled and the defendant had to answer. The defendant who was driving under the influence: yes. Plaintiff's counsel: and isn't it true that in that prior driving under the influence incident a child died? You can imagine the reaction in the courtroom and among the jury. Just when you think it is over, plaintiff's counsel went for the jugular. Do you remember the name of the child you killed while driving under the influence? In my opinion, this question is one for the ages, more powerful than the old question, when did you stop beating your wife? Because no matter how the defendant answers, and that is why you never lie to your attorney. Story 30. I had a client who, despite being a large man, had been domestically abused by his much smaller wife throughout their marriage. After the divorce, she turned her anger on their son. He ran away one day to live with his father, and we filed to restrict her parenting time and to seek a permanent modification. At the permanent hearing, she denied being abusive to the child or to my client in front of the child, said she had never threatened anyone or made disparaging remarks about my client in front of their son. What she did not know, and therefore had not told her attorney, was that he had recorded multiple instances of her abuse. I called my client back for rebuttal and played an audio recording of her screaming at my client, threatening to break his face in, and calling him a loser, all while the child could be heard in the background begging her to stop. I looked over at the other attorney. She had her face in her hands. We won. Story 31. Not me, but my mentor. This is the reason you never ask questions in court that you do not already know the answer to. During a divorce trial, the wife testified that he had abused her during the marriage. The client whispered to my mentor that this was absolutely not true. On the stand, during his testimony, my mentor asked, "At any point in the marriage did you lay your hands on your wife?" He answered, "One time we were having an argument and I held her down on the couch until she stopped arguing with me." My mentor said she felt like she could see it happening in slow motion and all the alarm bells went off in her head because he had never mentioned this before and, apparently to him, this was not abuse. The judge awarded the wife a much larger settlement as a result and the husband was baffled. My mentor was furious. Update. The husband admitted this was the only time he had laid hands on his wife. My mentor was especially upset because she had thought the case was in the bag. The wife had abandoned the children with the husband to run off with her lover to Florida, and had only returned to the state to finalize the divorce. The husband had been noted as a great father and a respected member of the community, which is why my mentor was so shocked by his answer. Story 32. I was approached by an attorney who asked me to work for him for free to pursue smugglers. This man had been arrested for dumping goods into United States markets in violation of trade agreements. When he was arrested, a large quantity of goods was left in warehouses to rot, and the owners, his clients, were never paid. The attorney showed me that the smuggler had assets and that he had gone to the criminal trial and persuaded the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, and all necessary paperwork. He only needed associates to help take the case to trial. He wanted me to work for free, but he said he would pay me on a contingency basis once he obtained a verdict. He had 2 other attorneys on the same contingency arrangement. I worked on the case for a short time, but then moved on to other matters. The other 2 attorneys worked on the case for over 2 years. At one point, they negotiated a settlement of $1,500,000 for all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200,000 because none of the clients would enter the United States to testify for fear of being arrested. The 2 associates received $8,000 apiece for 2 years of work. Story 33. Years ago, I represented a client charged with public intoxication. It was a minor infraction, but he was on probation, so he needed to fight it. He told me he had been very drunk that night, but had made it to the lobby of his brother's apartment and was waiting for his brother to come down and take him upstairs. I took that information and ran with it, bringing photos of the apartment complex and the bylaws to court. My goal was to show that the lobby was restricted to residents and guests, which would argue that he was not in public. There was no formal discovery for minor infractions in my state. Since there was no real option for a plea deal on the minor charge and I wanted to ambush the officer with my argument, I did not discuss the case with the arresting officer and we went to trial. The wheels came off when the officer testified that he had encountered my client at an apartment building on the other side of the city. My client was outside at the call box, not in the lobby of that building, rambling and barely able to stand. I whispered this to him, and he slumped and said he had meant to go to his brother's apartment and that his brother might not have found him because he had sounded angry on the phone. Cross-examination was not fruitful. The best I could do was ask whether the officer was sure the incident occurred where he testified and not at the other apartment building miles away. The closing argument that my client was not that drunk also failed. In the end, there was a quick guilty finding, a minor fine, wasted ink and paper on useless exhibits, and light sanctions later for the probation violation. Story 34. Sorry, I cannot assist with content that sexualizes minors. Here is a sanitized version suitable for text-to-speech. Employment law matter. He claimed he was unfairly dismissed over alleged performance management. The employer's real reason was misconduct. He used an online classified to arrange collection of a soiled item from a public location and sent explicit messages asking what was done with it and whether others had handled it. The employer provided the messages. He was doing this on company time. Story 35. I was on a jury. A man sued a business, claiming he was injured and could not work for 3 years. Defense counsel asked, "Sir, isn't it true that you spent 18 of those months in prison for armed robbery?" The man said he had been shopping at a major grocery store chain and slipped in water on the floor in front of a freezer. He had a cell phone video his wife made of him in the water. We could hear her say that the water did not show up on video and to splash it with his hand so it would look better. It also emerged that he had 3 prior convictions for crimes involving dishonesty, such as shoplifting and other petty offenses. He was representing himself. Defense counsel asked if his inability to work could be related to 2 previous knee injuries. When asked how they knew about those injuries, he was told his previous lawyer had given the defense his medical records upon request. He wanted to enter his magnetic resonance imaging scans as evidence but had no expert witness to explain them to the jury. He wanted to explain the results himself. Story 36. Not my story, but I went to court over a ticket. The woman in front of me was facing charges of driving under the influence and hit and run. The judge assigned a lawyer for her because she was so shaken she had quit her job. When the judge asked the prosecuting attorney for details on the case, the woman literally said, "You mean that car I hit while I was intoxicated?" The judge stopped, took his glasses off and said, "Everything is recorded in this courtroom. I told you not to talk to anyone about your case except the attorney I assigned for you." You could tell he was ready to walk out of the room, given how foolish her statement was. Story 37. United Kingdom. I am not a lawyer but a planning consultant. A client signed a sworn affidavit stating that he had been running a truck park on a piece of land for over 10 years. After 10 years, the use becomes immune from legal action. The counsel checked Google Maps and immediately saw that he had lied. He had only run the business for 7 years. He had committed a criminal offense by submitting a false affidavit. Plonker. Story 38. When I was an intern at the courthouse, I was watching a battery trial with another intern. The defendant was asked if he could remember how many people were present when he had assaulted another man. He then pointed at my fellow intern and said rather loudly, "She was there, but she didn't see anything. Don't trust her." Of course, she had not been there, and the defendant was found guilty. Story 39. A defendant was issued a cell phone ticket while driving and defended himself. "Your Honor, I was not using a smartphone while driving. I was actually using a flip phone." Guilty. Story 40. Not strictly a court case, but boneheaded stupidity. Several people gave false names to the police to avoid arrest and were arrested when those names matched individuals with outstanding warrants. Story 41. Unfair dismissal case. The client claimed that he had been dismissed without reason or without following the required procedure. After we had started the case, it emerged that he had been given 3 written warnings and had been called to a disciplinary hearing before his dismissal. Do not lie to your lawyer. Story 42. And estate matter. A client neglected to tell me he had 4 children from a previous marriage. Guess who showed up to challenge the will after he died? They lost, but I would have drafted his will differently had I known. Story 43. I'm not a lawyer, but I am going to law school. I worked for a defense attorney who handled a lot of federal cases. One case involved a man charged with sex trafficking of minors. We met him in prison to interview him. He insisted he had nothing to do with it and did not even know the girls. About a month later, a large amount of evidence from the United States Attorney's Office arrived. Pages of Snapchat messages and text messages between him and the girls. Video confessions from co-defendants and victims identifying him as the ringleader. Proof that he checked in and out of different motel rooms and more. We showed him the evidence and he said his co-defendants were conspiring against him. He continued to deny everything and wanted to go to trial, but we repeatedly told him that would not be wise given the evidence against him. He ultimately requested that a new attorney be appointed, claiming we were ineffective. To this day, my former boss and I reminisce about how difficult that client was when we catch up by phone. Story 44. I am not a lawyer, but a woman I know received several hefty speeding fines. In my country, you can go to a magistrate to have the fines reduced if you plead poverty. She decided to try, went to court, and told the magistrate a sob story about not having enough money. The magistrate listened and then asked, "Madam, what type of car do you drive?" She replied in a tiny voice, "A Porsche." To be clear, the Porsche was not an old or beat-up model. She was wealthy and could have paid the fines without breaking the bank. She was just pushing her luck. The magistrate was not having any of it. Story 45. My father represented a man in a civil case. He does not normally handle criminal law, but a question of a forged signature came up and the client lied, denying he had forged it. My father explained clearly that admitting it to him would not lead to jail. It would only allow him to build a better defense. The client still denied the forgery, so my father proceeded. The case was ruined when it emerged that the client had forged the signature. Everyone, your lawyers are not snitches. They are trying to get you the best possible result. Always be honest with your lawyer. Story 46. Summary. The client forged the bank statements on which her entire wrongful foreclosure case was based. We had clients who said the bank wrongly foreclosed on their home. The wife provided bank statements for their checking account, which was at a different bank than their mortgage, showing that they had made their payments every month for several years. I reviewed each statement to confirm the payments and that everything looked consistent. There was also evidence that the notice of foreclosure had never been delivered to them. The bank was baffled. Expert witnesses we consulted confirmed that during the recession many banks' record-keeping had deteriorated, and a wrongful foreclosure could result from that. At mediation, The bank responded that, upon close review, it had found a small error in the bank statements and was terminating mediation and issuing subpoenas to obtain statements from the bank for comparison. Our clients were angry, as were we. What if the bank had made a small error? A few weeks later, the bank produced the subpoenaed statements. I compared them and noticed discrepancies in the electronic withdrawal section. Our client had used a portable document format editor to delete an entry in that section on every statement, add a mortgage payment, and then adjust the totals, carrying the change forward each month. We confronted our clients and said these documents appeared forged. We offered to drop the case if they would explain the issue. The wife said they should probably drop the case. She never expressly confessed to forging the statements, but it was clear she had. Her husband had no idea. He was not on the call where we raised the forgery, and he called a few weeks later asking for an update. It was difficult to tell him his wife had lied to him for the past year and a half. The opposing side said they would agree to dismissal if our clients paid their attorney fees. Our clients agreed. It was fortunate the bank did not pursue criminal charges. Story 47. I am not a lawyer, but I was a manager in an unfair dismissal case. One of the shift supervisors reported that a call center worker was making personal phone calls during his shift. All employees sign an agreement that they are not to use office phones for personal calls. She told me what she had heard. We checked the phone records and found he had made over a dozen calls to the same number in the previous week. It was clear they were personal calls because they were to a gay telephone sex line. The specific number was irrelevant to me, but given the potentially sensitive nature of the calls, I decided to call him into the office with witnesses, discuss what we had found, and issue an official warning. I had the warning typed and printed. When he came into the office with his chosen witness, I asked if he was aware of the company's policy on personal calls, and he said yes. I showed him the number he had been dialing and asked if he recognized it and if he had called it from the office phones. He immediately lost his temper, started yelling, kicked his chair against the wall, then shouted that he quit and stormed through the call center shouting profanities. I informed my manager and the Human Resources Department and obtained statements from everyone involved, including his witness. 2 days later, he returned to the office with his solicitor, demanding an immediate meeting with the general manager. His solicitor demanded a large compensation payout, insisted I be immediately fired, and threatened to pursue criminal charges against me personally for hate crimes, claiming that I had fired him for being gay. The general manager asked me to give my side of the story. I showed the solicitor the signed agreement about the personal calls policy, the call records showing all the calls he had made during his shifts, and the printed warning I had prepared for making personal calls. I pointed out that at no point had the fact the calls were to a sex line been the issue, and that his sexuality had nothing to do with what had happened. I also had signed statements from 3 witnesses that he had quit, not been fired, and reminded the solicitor that the company had only intended to give him a warning. The solicitor took 2 or 3 deep breaths, apologized to the general manager and to me for wasting our time, specifically apologized to me for the threats of legal action which were not justified in light of the actual evidence, and left, pulling his client behind him. 2 weeks later, I received a call from another call center where I had previously worked, asking for a reference for him. Story 48. It was a simple bond hearing on a bad check case for $5,000, a felony. The biggest issue with these is that the judge just wants to be sure my client will come back for the new court date. I had been hired the evening before by the client's crying, panicked wife, so I did not get a chance to talk with him until right before the hearing. That morning I asked if he had ever been in trouble before. He had some minor charges in the past, but those had been resolved. He was now in his 40s and said he had been clean. So far we were golden. Me. Have you ever failed to appear in court before? Client. After some thought. Way back in college I missed one court date because I was stupid. But that was it. Me. Concerned about his pause. Are you sure? Client. Yes. We were good. He had an economic offense, was established in the community, had been out of trouble for years, and had only missed one court date. This should work. We got before the judge and I presented my case for bond. I went through my notes, presented my argument, and the judge patiently listened. When I was done, Judge So this failure to appear was just because he was an irresponsible college student? Yes, Your Honor. He now understands the importance of meeting his obligations to the court, including appearing when required. That was just a youthful mistake. Judge. Very well. I understand. Can you explain the other 9 failures to appear that also show up on his record? I went from calm confidence to embarrassment to barely controlled anger to what I hoped was a neutral expression. I looked at the client, and clearly the now 10 failures to appear were not as surprising to him as they were to me. Since he was pulling off the calm, confident look much better than I was, I turned back to the judge and said, I think he is in a better position to explain those right now. We got through the hearing. The judge was angry, I was angry, and he was just as calm. Although he was finally able to get bond, he had to borrow money from his family because he had to put down a lot more money than he expected. Do not lie to your attorney. Story 49. When I was a law student, I interned for a judge. One of the cases we observed was an illegal lockout, where the owner of a franchise location for an international cafe company claimed the landlord, who also owned the rights to issue franchises in the United States, had locked him out one day. The landlord alleged the franchise owner was selling unapproved merchandise with the company's logo. For 2 days, all we heard was about these cups the plaintiff allegedly made. The argument was that counterfeit merchandise violated the terms of the franchise agreement and the lease, which would terminate both. Finally, the landlord was on the stand. The defense attorney pulled out a shopping bag as he was about to introduce evidence. The other interns and I were so excited. For 2 days we had been hearing about those cups. And then the landlord suddenly could not remember where he got them. In response to one question he said he got them at the cafe. In another he said the corporate office gave them to him. Because he raised doubt about the source, the judge would not admit them, and we never saw the cups. The defense attorney had to put the bag back in his briefcase. Lesson learned. Prepare your witnesses, especially when you are introducing critical evidence. Story 50. Pre-existing medical conditions. We will all learn about your prior treatment. Tell your lawyer. Story 51. A postcard. While I was in law school, I worked in a state attorney general's office administrative appeals division. A man was appealing a large tax bill for unpaid tax on his dairy farm's milk production. His entire defense and claimed basis for the appeal was that he had no notice of the requirements to report production, sales, and proceeds. In the initial disclosures, among the discovery was a postcard sent by the state tax office when he registered to obtain a state tax number. A very smart assistant attorney general held the postcard back and introduced it after the client had already cemented his position in many ways. The postcard destroyed his entire theory and led to a large judgment against him. Moral: read your own discovery responses and document production before building your entire theory of the case. One piece of paper can kill your client's position. This lesson has saved me many times during my 27 years of practice. Story 52. I am not a lawyer. My parents had a long, messy divorce that took 2.5 years in court. My dad claimed my mother was trying to take 100% of everything based on a settlement offer she sent him. He failed to tell his lawyers that her initial offer, which she had also sent to his previous lawyers, was a 60-40 split. She only sent the 100% offer in response to an equally unreasonable offer from him. As soon as she could prove the initial offer was reasonable, the judge ruled on everything according to that first offer. His lawyers were very angry because they had built their case around the idea that she was the unreasonable one. I think the argument was that she was not sending genuine settlement offers. His goal was not to win. It was to prolong the battle. The original offer exposed his lie in front of the judge, which made the rest of the process go very quickly. Story 53. Something unexpected but worth telling. Years ago, I assisted an attorney whose client had been caught in a drug sting operation. After a meticulous review of the discovery materials, we found that the officer who prepared the arrest report failed to document any possession of a controlled substance by the defendant. The man was released the same day for time already served. Story 54. I had a workers' compensation case in which a claimant said he fell off the side of his truck while putting a tarp over the load and injured his back. It seemed legitimate because he was taken to a hospital and given medication. While pursuing the case, we learned the company had a surveillance camera. The employer reviewed the recording because the injury seemed suspicious. The video showed the claimant climbed off the side of the truck, lay down on the ground, and began shouting for help. He had fabricated the injury. No wonder employers questioned workers' compensation claims. This claimant harmed legitimate claimants. Story 55. My parents spent most of my childhood embroiled in a messy divorce, and they were still arguing years after I had left home, to be honest. One of their biggest arguments was about my parentage. My mom said my dad claimed I was not his child, and she refused to engage with him until he admitted he was wrong. My dad refused to admit he was wrong and would not engage with my mom until she apologized. Much later, I found out that those years of arguing were due to a typo on a court document that listed my date of birth 10 years later, making it appear I was born after my dad had a vasectomy. Neither mentioned the obvious typo to their legal representatives. I guess they thought fighting pointless battles in court for more than 5 years was preferable to simply amending one number on a document. One parent in particular went through multiple solicitors and barristers, insisting that each one had mismanaged the case, and to this day remains convinced they were a model client who just had bad luck choosing representation. Thanks a bunch for sticking around till the end of the video. Remember to subscribe, and until next time, stay awesome and goodbye.